Hi, my name is Lori Kornblum. I'm an attorney and I'm an instructor here at MATC in the Paralegal Department. We are continuing our series of legal research in action, but today we are just going to talk about how to read a case. Today we are going to look specifically at a case called In the Marriage of Lang versus Lang, which you may recall we found when we were looking for Wisconsin cases. I found this case by going to the Wisconsin's Callahan Reports, 175 Wisconsin 2nd, and we know that it starts at page 373 because we previously looked at the citation. The first thing is, in the case we see that there is a complete caption. In the marriage of Elizabeth A. Lang, petitioner respondent, versus Robert P. Lang, respondent appellant, and we know it's in the Court of Appeals. Now, when we would write out the citation for the case, we would just say in re marriage of Lang versus Lang, because all these names are just way too much, and that's not proper citation format. So the next thing we know is that it's in the Court of Appeals, so we know procedurally where it's at, and we know that this is the docket number 91-0133, and it was submitted on briefs in February of 1992 and decided on March 19, 1993. So we know that this case took a long time to decide. They do not have the official reporter citation here. After you have the case citation, you have a number of notes, and you see the first one is divorce. It has a section number, and this is just a summary of the case and different kinds of research topics that are in the case. So if you looked at one of these notes, let's say you wanted to learn more about the rights of custodial parents and selection of religion, you might go to that divorce section 173.25, and you might see other cases about that. These notes go on for some time, but keep in mind that you cannot cite the notes for anything. These are not an official part of the case. These are an editor's vision or reading of what is in the case. It is correct or incorrect depending on whether you agree or disagree with them, but it has nothing to do with what the judges say. So after you have the case notes, you see procedurally where it is. It is an appeal from a judgment of the circuit court. This comes from Clark County, which is way up north, and the judge is Michael W. Brennan. It tells you who the attorneys are, Richard Martin from Milwaukee, and it tells you who the attorneys are for the petitioner, and it tells you who the judges are who heard the case. Gartsky, PJ means presiding judge, Dykeman, and Sunby, JJ means judges. Then where it says Gartsky, PJ, that is where the opinion starts. The normal format of a case is, in the case, it will normally start off with a summary of what they're going to talk about, and then they get to the facts of the case. Sometimes in the facts, they call it different things, but whenever they start talking about what actually happened, those are facts. In many cases, the judges will then go into what they call the discussion, and that's where they really start doing the legal analysis. But in this case, they do not have a subheading called discussion. And there's just a paragraph that's introducing it that talks about dividing the review between the validity of the restriction, and that is the restriction on the father's visitation due to religion under the Wisconsin Constitution and the U.S. Constitution. And then they go on to discuss validity under the Wisconsin law. This is under the IRAC form, where you would start with the IRAC, the issue, rule, application, conclusion. So the court cites the statute, which is the rule, and they actually go through the statute. And then you see this little number 1. That again is a reference to the headnote that the legal editors have about this case. It is not actually part of the decision. It is the editorial part. And the court goes on to talk about it, and then they talk about something in headnote 2, or what the editors have pulled out for headnote 2. And what they are is they are investigating the statutes and they're discussing them. So the case goes on and discusses whether this is reasonable. What you have just seen is the application section. Now we get to the conclusion that the restriction is valid under the laws of this state, and then they're going to discuss whether it's valid under the U.S. and Wisconsin constitutions. So without reading the entire opinion, we can find out that we go to the bottom and we see that they're concluding that the visitation restriction does not violate the rights, and it's affirming the judgment. Now you see that there is a dissenting judge who disagrees with the majority. However, the dissenting judge, however persuasive Judge Dykman might be, he did not write in the majority. So his opinion is important for the discussion, but it is not the majority opinion. So there you have it on how to read a case. And that concludes our video for today on how to read a case.